Well, good evening, everyone. Buenas noches a todos. Eh, Feliz Viernes. Happy Friday to everyone that's joining us tonight. I know it's Friday and it's nice and warm out there. And so I wanted to take this opportunity to thank everyone for making time to really get to understand what legal documents are necessary during this COVID-19 pandemic and even the ones after. Buenas noches a todos. Le quiero dar las gracias a todos por venir. Sé que estamos hoy día viernes, feliz viernes. Sé que hay muchas cosas que podemos hacer hoy, ya del fin de semana, pero es importante y estoy muy contenta de ver que ustedes están asistiendo a este webinario para aprender un poquito más en términos de cuáles son los documentos legales que se necesitan durante esta pandemia y después de la pandemia. Así que le quiero dar las gracias a todos por unirse a nosotros y a Emily Klotz, que es la abogada que va a estar con nosotros. Again, I want to thank everyone for joining us on this Friday evening, joining us as well as Emily Klotz, who's also with us. She's the attorney who's going to speak on this. We're honored that you guys are on the call with us today. But we want to introduce this wonderful attorney who we recently met, and she volunteered her services to us to be able to have this very timely and important webinar. And the reason why we are having this webinar is because there's only one thing for sure in this world, and it's that we are born and we die. So for all of those of you that know me well, you always know, and I would say probably say it on every call, I always tell people don't plan to fail, they fail to plan. So even if we are in great shape right now, even if we are super poor right now, we do not know if we're going to win the lottery tomorrow. The idea is that we should prepare and we should be informed as to what legal documents we really need during this time and after. And we're going to do a series of these type of webinars to help you really manage your financials as well. We're going to go as far as even talk about Medicaid. So there's going to be a series of these calls because I think it's not just about, Palanta is not just about housing. It's about empowerment. It's about providing you guys the tools that you need in order to succeed, for your families to succeed. We want to make sure that you guys leave intergenerational wealth as well. So we're going to focus on that in addition to obviously, COVID-19 rent relief, COVID-19 food relief. And of course, when we open our office, we're going to be bringing you guys in one by one, by appointment as always, and assisting you with any additional paperwork you guys need, including, lease renewals, getting your spouses on the lease, which we also found out that a lot of you guys don't have your spouses on the lease simply because the landlord said no. So that being said, I'm going to stay quiet now. I'm going to pass this over to Emily Klotz. Emily?
Hi, everyone. My name is Emily Klotz. I'm an attorney in New York City, and I'm going to talk to you today about various documents. And I thought we would start with the healthcare proxy and a living will. Everyone should have a healthcare proxy. A healthcare proxy allows you to name someone to make healthcare decisions for you if you cannot make those decisions for yourself. If you're under general anesthesia, if you're confused, if you're unconscious, if you are on medication that's clouding your judgment, a healthcare proxy, an agent under a healthcare proxy can make those medical decisions for yourself. The person you name can be a family member, a friend, a spiritual guide, a spiritual person like a priest, or anyone else. But you can only name one person at a time. The doctors, when this law was developed, the doctors didn't want to have to deal with a team of people. It's one person at a time who can be your spokesperson. That one person can speak to other family members if you'll allow it. In the healthcare proxy, however, you can name an alternate person. So if you name one person and the doctors can't reach that person, then the alternate healthcare agent, they'll reach out to. You can name as many alternates as you want. I've never seen more than 3 or 4. And we usually include in a healthcare proxy cell phone and landline if you have a landline, so that that person can be reached. Your healthcare proxy can include your wishes in the document, very specific, I want medication, I want a transfusion, I don't, or you can leave the authority to make the decision up to the person you name to carry out your wishes and directives. You really need, however, to have a discussion with that person, the person or people you name, to make sure that that person or people knows what you want, and that that person is going to follow what you want, even if the person you name disagrees with that choice. I'm going to give you a personal example. When I was about 22, my aunt, believe me, that was many years ago, my aunt decided she wanted she had cancer and she did not want chemotherapy. I wanted to keep her around. She named me as her healthcare agent because she knew that I would follow whatever she said, even if I disagreed with it. And so that's very important. My office often gets phone calls that's from a person who says, I'm my husband's healthcare agent, what should I do? And I tell that person, it's not what you should do, it's what your husband or your wife or your child would have wanted you to do. Next slide, please. Okay. This is a copy of the healthcare proxy from the Department of Health. I've also included, I don't know if you've received it, a copy of the healthcare proxy from my office that I prepare. But in this healthcare proxy, it shows that I, Emily Klotz, hereby appoint whomever I've appointed as my healthcare agent. And then paragraph 2 says the optional agent, and so on down the line. Powers of healthcare proxies can be limited in term. That is, you can say this healthcare proxy is only good for the next 30 days, or it can be an unlimited term. I usually recommend an unlimited term so that you don't have to keep re-executing this document. The document does not have to be notarized. You need to sign it, and then it needs to be witnessed by 2 witnesses, signed and dated and witnessed by 2 witnesses. It can be revoked at any time. You just have to tell your healthcare agent. Next slide, please. Now, a lot of people have heard about something called a living will. Living will is different from a healthcare proxy in that a healthcare proxy, first of all, is activated the moment you sign it. So that if you're just going for a surgery and you're under general anesthesia and the doctor has a question, the doctor can speak to your healthcare agent. A living will is only used if you're terminally ill, you're in a coma, or you're otherwise unconscious and not likely to come back, and you're incapable of expressing your wishes. Also, it's different from a healthcare proxy in that mostly in a healthcare proxy, you appoint a person to make the medical decision. In a living will, you outline what you want and you don't want in terms of a medical intervention. So you can say, I don't want to be resuscitated at the end of my life. I do want to be resuscitated. I don't want to have my chest cracked open and my heart massaged. I do want that. I don't want antibiotics. I don't want chemotherapy, whatever it is. Also, a living will is not enforceable in court. So if you say to the doctor, this is what I want, and this is the person I'm naming as my agent, but you only have a living will, and the doctor disagrees and doesn't say, and doesn't listen to the agent, that agent cannot go into court to force the doctor to follow the agent's directions. Only if you have a healthcare proxy can that person go into court to compel the doctor to pay attention. But not everyone has someone to name, especially if you're older and you've outlived your friends and your family. You don't have an agent to name. And so a living will is a helpful document to have if you don't have someone to name, but want the doctor to know what you want and what you don't want. So doctors and other medical providers rely on a living will, but again, it cannot be enforced in court. Can we have the next slide, please? Okay. Once you've signed your healthcare proxy and your living will, if you do a living will, you give it to all your treating doctors while you're well. And that is so the doctor can say, are you sure you want this person to be your agent? Are you sure you want this to you want this treatment, or you don't want to have this treatment? Now, when I say all your doctors, you don't have to give it to your foot doctor, but you need to give it to your primary doctor if you have one, an oncologist, someone who's treating you for cancer or for diabetes, or for any or cardiologist for your heart, any life-changing type of doctor. Okay, next questions. All right, so if you don't have a living will or you don't have a healthcare proxy, because so many people were not signing these, the law, the New York State Legislature in 2010 created the Family Healthcare Decision Act. Next slide, please. The Family Healthcare Decision Act allows a patient's family member or a close friend to make decisions for the patient who is in a hospital or a nursing home. So this does not apply to out of a long-term facilities situation. That is, you can't, the agent can't go into a doctor's office and say, well, I know you're treating this person for diabetes and I want to look at the medical records. That's not in the Healthcare Decision Act, but it is in a healthcare proxy. A healthcare agent can do that. Under the Family Healthcare Decision Act, someone who is in a hospital or a nursing home or other long-term care facility, a rehab facility, for example, can, that person's relatives or friend can make medical decisions if the patient lacks the ability to make that kind of medical decision. It's called a surrogate decision maker. The surrogate decision maker has the authority, amongst other things, to direct the withdrawal or withholding of life-sustaining treatment. That means they can hold back nutrition and hydration or medications. And it also includes consenting to a do not resuscitate order under certain circumstances. Next, thank you. The law only applies to patients in a nursing home and a hospital who has lost the capacity to make decisions. And private hospitals and individual healthcare providers are not required to honor the decisions made pursuant to the Family Healthcare Decision Act. Next, thank you. For the surrogate to be allowed to make the medical decisions, there first has to be a determination that the patient doesn't have capacity to make his or her own decisions. Everyone is presumed to have decision-making capacity unless it's determined otherwise. So unless there's a legal guardian who has been appointed pursuant to a court order, the law outlines first how the initial determination is made. It has to be made by a doctor attending you, and the determination must include the assessment of the cause and extent of the incapacity and whether or not he or she will regain capacity. That means someone's had a heart attack and is unconscious, may or may not be able to come back from the heart attack. That's the kind of thing that the doctor has to make a determination about. And then a second doctor has to confirm the first doctor's diagnosis and determination. Next slide, please. Okay. In a nursing home, it doesn't have to be a doctor. It could be a social worker or other health practitioners, like a nurse practitioner can independently confirm that the patient lacks decision-making capacity. In a hospital, it could be a social worker. It's required only when the surrogate's decision involves withholding life-sustaining treatment. And if there's a dispute as to whether the person is incapacitated or not, then the matter has to be referred to the facility's ethics review committee to determine whether the person has capacity to make medical decisions or not. Next slide, please. Okay, so if there's been a determination under the Family Healthcare Decision Act that the person is unable to make his own decisions, then the law outlines who can make the decisions for you. First is a legal guardian appointed by the court under what's called Article 81, and that's a guardianship. Second is the spouse or domestic partner. Third is an adult child. Fourth is a parent. Fifth is a brother or sister. Sixth is a close friend who's over the age of 18, but that's very rarely accepted. The problem with the Family Healthcare Decision Act is that it doesn't say which adult child. So let's say you have 3 children and 2 say one thing and 1 says another, or all 3 are saying different things. The law doesn't distinguish which adult child should make that decision. Or if you have brothers and sisters, again, if they disagree, there's no determination. It's not that the oldest brother or sister goes first. And so it becomes a problem. That's why a healthcare proxy would be a much better tool in order to manage end-of-life decisions and even ongoing daily life decisions. Some people don't really like to deal with reading their medical charts or dealing with the doctor. And so a healthcare agent under a healthcare proxy can review medical charts if you allow him or her to do so, talk to the doctor if you're unclear about what the doctor said. That's all possible only with a healthcare proxy. Okay. Should we go into questions now about healthcare proxies before I go on to the next topic? All right, I'm not getting an answer.
Yeah, I think you should just, let's go on to the next topic. So this way we'll collect the questions afterwards. Anyone that has questions, they can start putting it on the Q&A section. They can just start typing it and then we'll definitely answer them.
Okay, so in the next document that's a very important document to have is a document called a power of attorney. And in that document, you can name one or more than one person to handle your finances, sign your leases, negotiate settlements if you have a personal injury action or other lawsuit, help you with your finances, do your banking, or otherwise act on your behalf if you're not able to do so. Or even if you are able to do so and don't want to bother. May I have the next slide, please? Okay. So it's a legal document. There's a legal document called a statutory statutory power of attorney, which I provided to Palante. And that particular document, the first 10 pages or so, cannot be altered, or it cannot be altered very much. And it lists, for example, who you want as your agent or agents, and whether, if you name more than one agent, if they can act separately or together. I will tell you that banks these days are reluctant to allow 2 people to have to sign on one check. So it's better if you do name 2 people to have them act separately. Also, it outlines all of the various powers that you can convey, going from just one power, just dealing with leases, to everything. It goes from A through P, I think, or Q. And you only have to, if you're going to give someone all the power, you only have to initial that last portion. Otherwise, if you want to limit it to, let's say, just banking, that's where you would have to initial just that little area in the power of attorney. The power of attorney also gives you the authority to name a monitor. What happened previously is that you would name a power of attorney, you'd name an agent under the power of attorney, and that agent could run with it. And unless you yourself objected to what the agent was doing, the agent's actions could not be challenged. And again, I'm going to give you a war story. I had a lovely little man. He was just a darling man who was in his 90s. He had lost his wife. He had lost his son, unfortunately, and he gave a neighbor his power of attorney. And unless this man started cross-dressing at the age of 91, Victoria's Secrets was getting a lot of charges that he was paying for. And Home Shopping Network was getting charged for king-size bed when he was sleeping in a twin. And it was the woman who he had given the power of attorney, the authority under the power of attorney. I found this out, and I went to the district attorney. There is a district attorney in every county that is supposed to deal with elder abuse. And I reported her, and the district attorney said, well, she gave him the power of attorney and only he can challenge it. Well, he was not able to do that. He was mentally impaired and he could not challenge her. So she was taking advantage of this situation, which was terrible. It was resolved eventually, and I got her to withdraw as the agent. Nevertheless, that's the type of situation that the monitor, now that the new power of attorney names a monitor, the monitor can oversee the actions taken on your behalf by your agent. So if you're naming a neighbor as opposed to a family member, let's say, or you don't trust your family member, you should name a monitor in the power of attorney. So if prepared properly, the power of attorney gives the person you name the ability to deal directly with banks, landlords, insurance companies, government agencies, Medicare, Medicaid, Section 8, all of that. Also, if the document is prepared properly, the authorized agent can make gifts or transfers of funds to engage in Medicaid planning in conjunction with an asset protection plan. And we'll talk about that a little bit later. That is not in the standard form. It has to be customized for you in order to allow your agents to do that. Now, the power of attorney is durable, which means it takes effect and remains in effect even if you're declared incapacitated, or you are, but it ends when you die. Most people don't realize that. The power of attorney terminates when you die. So your agent cannot do things after you die. The new power of attorney requires that the agent sign the power of attorney to make it effective. In the old days, before this new power of attorney came along, people would say, you know, I want my cousin to be the agent, but I don't want her to get the authority to do it now. I don't trust her that much. I only trust her in an emergency. So that person couldn't sign the power of attorney, and often it became too late to sign the power of attorney when it needed to be exercised or used. So the new, it's not new, it's from about 2012, the power of attorney that's currently in effect, you sign the power of attorney, and then your agent signs the power of attorney either now, and then that will allow that person to act immediately, or the agent signs the power of attorney when it's needed. So when you're in the car accident, God forbid, or you're in the, you've had a stroke, that's when the agent can sign the power of attorney and start acting for you. Next slide, please. Okay. So a power of attorney, as I said before, will allow your agent to access a lot of important areas. So you have to, A, be very careful that it's a person you trust. Also, even though you do not need an attorney to prepare a healthcare proxy or a living will, but you really need an attorney to explain the power of attorney and customize the document for you. Next slide, please. Okay. The next area we're going to talk about is a last will and testament, which is the same thing as a will. And it's leaving a will is a way to ensure that your property goes to the people you want it to go to. And that the person who handles the estate is the person you want to handle the estate. Next slide, please. Okay. So a will, you can leave your assets a number of different ways. You can have a bank account that says payable on death to my sister. Or you can have life insurance, and the life insurance will be paid out to the named beneficiary. Or you can have joint ownership. You may own your condo, not so much with a co-op. You can have the shares held joint tenants with rights of survivorship. So that's outside of, that doesn't have to be included in your will. But the will can be used in conjunction with all of these things. You can create a trust, and the will can be used in conjunction with the trust. A will can also include gifts to anyone. It doesn't have to be a family member. It could be a relative, it could be a friend, it could be a neighbor, it could be your church or another charitable organization. You can divide up your assets. Very often you don't want, I often say don't leave an exact amount because you don't know how much you're going to have when you die. So you can leave a percentage. I leave 5% to my church and 2% to my neighbor who was taking care of me, and the rest I leave to my relatives, or any other way. But that way you don't leave $20,000 to the church and then you only die with $18,000 and none of your relatives get anything. You can also, in a will, create something called a pet trust. Lots of us have animals, and when you pass away, you don't know what's going to happen to those animals. You don't necessarily want it to go to a shelter. So you can create a trust in your will. You can also create a pet trust outside of a will, independently, to make provisions. I leave $10,000 in this pet trust for the care and feeding of my cat. And the person who is, I'm going to name my neighbor Sam as the person who's in charge of my cat. And the trustee of the trust, whoever you choose, pays over to Sam the cost of the vet bills, the cost of the food, etc. And in the pet trust, you can name the person who's going to take care of your pet as well. If you have minor children, in your will, you can name a person to take care of, to be the guardians of your minor children. And you can split it up to be the person who physically takes care of the minor children, and then another person who takes care of the money for the minor children. You want to make sure that the person you name as the guardian will be qualified to take care of your children with values similar to your own. In a trust, in a will, you can leave outright, you can leave money outright to someone, or you can create a trust. So often I'll recommend, if there are minor children, that you create a trust for the health, welfare, education of the children, and the guardian may be the trustee, and they'll use the money to make sure that they have proper education. If they need a tutor, that money can go to help pay for a tutor, can go for a college fund, and then after they're adults, I'm not so crazy about the idea of giving 18-year-olds a lot of money because they can very often blow it very easily. So you might want to arrange to have money distributed, a certain percentage at the age of 21, a certain percentage at the age of 25, and then the last of it at the age of 29, just as an example. Also, if you have a disabled child, you want to create in your will what's called a testamentary supplemental needs trust. That will allow your disabled child, or it doesn't have to be a child, just a disabled person you want to leave money to continue to qualify for government benefits like Medicaid or Section 8 housing or other government benefits. And the trust is a special kind of trust that protects the money from the government, and will protect the person who receives the trust, the beneficiary of the trust, will be able to continue to have government benefits. But it has to be a testamentary special needs trust. When that disabled person passes away, the disabled person, the money would go to a person you name as the ultimate beneficiary of the supplemental needs trust. I'm not sure I was clear about that, and I'll be happy to answer any questions. In a will, you name a person to handle your estate, a personal representative. That person would be called an executor or an executors. And the executor's responsibility is to gather up all of your pension and assets. If you've named a beneficiary to your pension, for example, that falls outside of the estate. It goes automatically to the beneficiary you named. But you may have a bank account, a checking account, and that has to be dealt with by the executor. And the executor is responsible for cleaning out your apartment, and for surrendering the apartment to the landlord, and for getting rid of your personal items and your furniture and your clothing. And then after 7 months after the person who was appointed the executor by the surrogate's court, that person is usually the person named in the will, then they can pay out to the beneficiaries of the estate the assets collected. In order for a will to be legally valid, it needs to be prepared and executed in strict compliance with state laws. So, for example, if you go onto zoom.com and get a simple will from them, they don't always tell you how to execute the will so that it will stand up in court. And it has to be presented to the court after you die in order for the executor to be confirmed and appointed by the court. So those are not the best documents. Once you've properly executed a will, it should be reviewed regularly because your life changes. The person you left your mother's watch to is now passed away, and you need to rethink your asset distribution. May I have the next slide, please? Next slide, please. Thank you. Okay, so an estate includes everything that you have. Everybody has an estate because everybody has something. All right, could you go back to this slide? The prior slide? Okay, it's all right. We don't have to go back. All right, great. So there are various estate planning tools, including a trust, including the will, including naming people as beneficiaries of bank accounts specifically. So that goes outside of your estate. But what happens if you die without a will? That's called intestacy. And some people think that it just goes to the state. Your assets go to the state, but that's not true. But the state decides who it goes to. Generally, a family member would have to petition the court to be appointed administrator. And once the court approves the petition and issues letters of administration, the administrator has the authority to do what an executor does: gather up your assets, pay off your creditors, sell your property, and then eventually distribute your assets. But it's not to the people you necessarily want it to get to. It's to blood relatives. So the next slide, please. Thank you. So if you have a spouse with no children, it all goes to your spouse. If you have a spouse and a child or children, even if it's not with that spouse, then it's split between the spouse and children. If there's a spouse and one child, it's 50% to the spouse and 50% to the one child. If it's a spouse and more than one children, it's a third to the spouse, 2/3 split among as many children as you ever had. If you had 6 children, 2/3 gets split between 6 children. If your child predeceases you, which unfortunately happens, that person's share goes to his or her children, if there are any. If you have no spouse and you have no children, it goes to your siblings in equal shares. And if they've predeceased you, it then goes to their children. So it would go to your nieces and nephews. So you have 4 siblings. Your estate is divided 4 ways. One of those siblings predeceased you but has 3 children. That 1/4 portion of the estate that would go to your deceased sibling would be divided among that person's children. And if you have no if you have no surviving nieces and nephews, then it may go to the state. Next slide, please. Oh, that's the end. Okay, so I did not prepare a PowerPoint about asset protection or prepaying a funeral, but in speaking with Ms. Vasquez, we thought that that might be something you folks would be interested in. So the first thing I'm going to talk about is prepaying your funeral. I think it's a great idea. You can go to any funeral home virtually in the state, and you can enter into a contract. You can pick out everything you want. You can pick out your coffin, where you're going to be buried, make all the arrangements and prepay it so that when the time comes, and should be 100 years from now, but when the time comes, all your family has to do is call up the funeral home and say, there's a contract in place, can you please take over? So that they don't have to make these decisions in the middle of mourning your loss. I have to tell you that I have 3 children. I love them dearly. I don't trust them for a minute to make the kind of plans that I want for my funeral. So I prepaid my funeral so that I know I'm getting what I wanted. I love them dearly. One of them is sitting in this room with me. I'm sure he's glaring at me, but I want it a certain way, and that's the way it's going to be. And probably my way is probably cheaper than they would go anyway. You can enter into what's called a pre-needs Medicaid approved contract. If you think you might be going onto Medicaid, which is different than Medicare, Medicaid is a needs-based program, then you need to enter into a Medicaid approved contract. What that means is that the contract is irrevocable. Once you sign that contract, you can't take the money back. But it doesn't mean you have to be buried where you first picked, unless you've already purchased the plot. It means if you say, well, I don't want to get a prepaid funeral yet because I don't know if I'm going to be buried here or back in the island I may have come from, or I may move to Florida or someplace else, and I don't know that I don't know what to do. The contract can be transferred to a different funeral parlor in the country that you die in or the state you die in, so that it can follow you. In addition, if you pay, let's say you pay $5,000 for a funeral, but you're well and you're not going to need it for many years, it earns interest. The money that you put into that contract is put into an escrow account and it earns interest. Believe me, the price of funerals go up all the time. So whatever you think you can pay now, it's going to cost more when you go. And that interest will go toward covering the cost, so that your relatives don't have to dig into their pockets at the, and scramble to find enough money to bury you. So that's pre-planning the funeral. Now, with respect to asset protection, you want to try and protect your assets so that your relative, you've worked all your life, you want your kids or your spouse to have some money, if possible. But God forbid you get sick, you need a nursing home, or you can stay home, which was much more ideal. You can stay home, but you need home care. That's extremely expensive. So you can, in certain ways, qualify for Medicaid by transferring your assets in certain ways to protect your assets in order to qualify for Medicaid. And assets include your savings, life insurance. It doesn't include your pension if your pension is in payout status. And it doesn't include life insurance if there's a cash out value to the life insurance. In other words, it's a kind of life insurance policy where you can terminate it early and get cash for the value of the policy, or a portion of the value of the policy. And asset protection, it's actually a very long conversation, which I'm more than happy to have under a different Zoom conversation about qualifying for Medicaid in order to get home care or nursing home care. Nursing home care, private pay nursing home, can range up to $16,000 a month, and more if someone has to go on a ventilator. Nobody can afford that, or not for very long. So if you transfer your assets appropriately ahead of time, then, and when I mean ahead of time, there's a look back period so that you might not qualify for Medicaid. So you want to do this earlier rather than later. If you transfer your assets ahead of time, the government will pay for either your nursing home or will pay for home care so that you can stay in your house, but your spouse doesn't have to necessarily bathe you or wash you. Your spouse may be ill or not physically able to manage that as well. So the government will send in home care workers to care for you, to help you shop, to help you cook, to prepare meals, to make sure you take your medications on time. They can't give you the medication, but they can remind you to take the medication. And it's important to consider what your family genetic history is. If you know it, you know that every member of your family has ended up with dementia or Alzheimer's. Maybe you need to think a little bit ahead of time to protect your assets so that you can leave something to your children or your spouse. You don't want your spouse eating dog food because he or she has had to put you in a nursing home. Okay, I'm not sure that I've answered any questions. I'll be more than happy to talk more about asset protection and Medicaid planning if you want, but maybe we can go over some questions first.
Yeah, this is terrific, Emily, and I thank you so much for doing this. I want to just go back to just the actual definition of an estate.
Oh, I'm sorry. Okay. So an estate is anything that you own when you die. It includes your bank accounts, it includes your furniture in your apartment, your books, your apartment itself, perhaps. But for the purposes of handling your estate, if you have, let's say, an IRA or a pension that names a beneficiary, when you signed up with your employer, you named your spouse or your children, that goes automatically to someone, to the named beneficiary, and it's not included in your estate for the purposes of paying off your creditors and things like that. Does that help, or do you want me to explain it further?
No, I think this is great. And then, so how do you go about creating a estate? How does it work? I'm asking for the folks that are not familiar with this lingo.
Okay, so before I do that, there's something that I forgot and I want to mention before I forget, okay? Well, you know what, I apologize. I'm going to go back and answer your question. You don't create an estate. You have it as you save money or you spend money and you buy a piece of artwork or a piece of furniture. Or anything you have when you die is your estate. The question really, I think, is how do you get someone appointed your personal representative to handle and dispose of those assets, those tchotchkes, those books, your clothing, your bank accounts, etc. All right. So if you die with $50,000 or less, your relatives, it's usually, and it's in closeness to blood, your relatives, that is your spouse and then your children, it wouldn't be a second cousin, it would be someone closer to you in blood, can go onto the surrogate court website in the county where you reside. So if you reside in New York County, you go onto the New York State surrogate court website and you click on small estate administration. This is for people with $50,000 or less. And it's a do-it-yourself. They don't want attorneys involved because they figure for $50,000, an attorney shouldn't get a fee from such a small estate. I don't think $50,000 is that small, but for the purposes of the court, it is. And you just follow, it's a do-it-yourself program. In the old days, pre-pandemic, if you were confused, you could actually go to the court and they would help you through it. Right now, there's no one in court to help you through it. And you submit the application, that what's called a petition for administration of a small estate. If there's a will, you submit the original will. And by the way, you never, if you have a will and you have to make a copy, do not take out the staples. Because if you take the staples out, the presumption is the will has been changed or altered in some way. And you have to then explain to the court that, no, you made a mistake, you took it out just to Xerox it, and you put it back exactly the same way. It creates a whole problem. In my office, we don't staple, we rivet so you can't take it out because we had too many people making that mistake. And you have to submit the original will and a death certificate. And then the court will process the application for you. And the fee is minimal. I think it's just like $2 or $3. If your estate is $50,000 or more, or you have a pending legal action, you only have $30,000, but you're expecting a workers' compensation lawsuit to come through where you're going to get more money, then the person named in the will, if you have one, the person named as the executor, or if not, a family member, usually spouse or children, if you have them, petitions the court to be appointed the representative of the estate. And in the case of, if there's a will, the will has to be presented to the court, the death certificate, the funeral bill, and a statement from the witnesses saying that they actually witnessed the will being signed and that the words that I said had to be said at the time were said. If you don't have a will, you die intestacy, then you also have to have a family member will apply to the court to be named as the executor, and they have to, or I'm sorry, administrator, and they have to actually prove that they were the person closest in blood to you so that they're the one authorized to act for your estate. The other thing I should tell you is that if you have a will that, let's say, leaves everybody, all of your brothers and sisters are out, but they are the people you would have normally who would normally have inherited the estate if there were no will, they have to be advised that there is a will, and they have to be advised that they have to see a copy of the will to show them that they've been excluded from the will. Or if they've been included, they still have to see a copy of the will. Those people are called distributees. That is, people who would inherit if there were no will. So it's not like your family is not going to know that you're passed away, even if you haven't talked to your brother in the last 30 years. That person is going to find out that you've passed away and that you haven't left him anything. Or you have left him something.
Well, I'm definitely learning a lot, Emily. I'm sure that the rest of the crew here are, this is new to a lot of us. So I want to thank you for, trying to break this down for us. Now,
I'm hoping I'm being clear.
No, you are, and this is terrific. In terms of a trust, can you define what is a trust and how do we go about doing a trust?
Of course. So a trust is actually just a contract. There are three parties to the contract. There's the grantor, that's the person who is creating the trust and funding the trust. There's the trust. Funding the trust means putting money into the trust or assets. It doesn't have to be money. It could be a house. It could be, well, with a pet trust, it's a little bit different. You don't actually put the pet in the trust, but you name the pet in the trust. Mm-hmm. Then there's the beneficiary of the trust, the person or persons who benefit from the creation of the trust, either at the time the trust is created or at the time later on when the trust ends. And I'll explain that in a minute. Mm-hmm. And then there is the trustee, the person who administers the trust, make sure the taxes are paid, make sure that all the bills are paid, etc. So the grantor, let's say I'm creating a trust and I put money into the trust and I name Ms. Vasquez as the trustee, mm-hmm. and my children as the ultimate beneficiaries. But in the meantime, I'm the beneficiary of the trust as well. So if I need my rent paid, Ms. Vasquez as the trustee uses the money in the trust to pay my rent, mm-hmm. or anything else that needs to be paid and that's permitted by the trust. Then when I pass away, if there's any money left over, the ultimate beneficiaries, my children, would receive the what's called the corpus, the body of the trust, whatever assets remain in the trust.
So let's say if I have a house in Mexico and I got another one in the Dominican Republic, does that property become part of that trust?
If you change the deed to the property into the trust. So the deed of let's say your trust is called the Elcia Vasquez Trust. Mm-hmm. You would have to take the deed to whatever property you have, change the title on the deed from Elcia Vasquez to the Elcia Vasquez Trust. And then it becomes part of the trust. Just like your bank accounts would be retitled from your name into the name of the trust. That's how you fund the trust.
This is great. This is so clear. This is perfect.
The trust can be, depending on your age, and I know this is going to sound strange, you can create a supplemental needs trust that would protect you if you become disabled and allow you to have benefits from the government, like Medicaid, okay? Mm-hmm. But you do it through a supplemental needs trust. I talked about doing that in your will, but you can also do it while you're alive. It's called a self-settled supplemental needs trust. Or someone else can do it for you. A parent or a grandparent can create that kind of a trust. Mm-hmm. That's a special kind of trust that protects your assets while you're alive. However, that kind of a trust, when you die, it has to, whatever's in that trust is paid over to Medicaid to the extent that you received benefits.
Mm-hmm.
So if your trust has $100,000 in it, and when you die, you used only 50%, $50,000 worth of Medicaid benefits, then $50,000 of your estate goes to repay Medicaid, and the other $50,000 goes to your heirs, the people who inherit from you. If, however, you had a $100,000 trust and you had a $500,000 worth of Medicaid benefits that you used up, you repay Medicaid up to what's in the trust, and then it's done. You don't repay anything further.
Mm-hmm.
Was that clear, or do I need to
No, I
try
think
and explain it
there
better?
is a way. How do you protect the trust from having to be for the government, right? Would the government come and take your money after you die? Like what sort of protection is there for someone? Let's say if I go out and I, put all my properties into this trust and I start funding the trust, I also start putting money in it. And then what happens, let's say that God forbid, I end up in a nursing home.
Well, if it's what's called a revocable trust, which means that you can change the terms of the trust, then you can't protect it from the government. If you create an irrevocable trust, meaning that once you put that money and those properties in there, you can't get them back out, then it's protected from the government so long as you don't look for government benefits for 5 years from the time you created and funded.
It's irrevocable.
Irrevocable, and there's a 5-year penalty period.
Uh-huh.
So that if you make it today, you cannot obtain or even apply for Medicaid benefits or other, it's usually Medicaid that people apply for, until 2025.
Okay.
You have to wait at least 5 years.
Wonderful. Well, I think we have some questions piling up right now. Robert, do you want to start reading the questions for us?
Absolutely.
I'm sure that they're going to be mostly for Emily, not for me.
Sure. Yes, we do have. I think this is one of the first questions that was posted early on. I am married, and if anything goes wrong with me, wouldn't my wife be my proxy automatically?
Your wife would be your proxy automatically under the Family Healthcare Decision Act. However, that only takes effect when you are unable to make decisions for yourself and you're toward the end of your life. So that if, let's say, you have to go in for surgery now and you're going to recover from the surgery, but but there's a problem in the surgery and they have to ask a question as to whether they should do something, then, and I'll give you an example, then they wouldn't necessarily look to your wife. Doctors are pretty liberal with this, as long as it's a husband and wife or husband and children, parent and child, but legally they don't have to listen to your wife because it's not an end of life decision. I had a friend who was going for surgery and she didn't want her mother to make medical decisions for her because she thought her mother was too emotional. So she named me as her healthcare proxy. And when they brought her in for surgery, they found something unexpected. And we had actually talked about every possible scenario, she and I, because I do this for a living. And they came out to me and they asked me what to do. And because I had had that discussion with her, I knew what she wanted. I was able to tell them, and they went back and took care of the problem. Had she not named me, they couldn't ask her mother because she wasn't terminally ill. They would have had to take her out of general anesthesia, sew her back up, let her recover, ask her what to do, put her back under general anesthesia, cut her back open, etc. So having that healthcare proxy really helped her. And in fact, it was limited to just that surgery. It doesn't continue today. Our friendship does, but that healthcare proxy does. Are there any other questions?
Yeah, there are.
Yes.
Oh, okay.
Could I just write Could I just write my wishes on paper instead of a will? My daughter is the only person I want to get everything.
The court does not have to acknowledge that will. If you have a wife or other children and you only want the daughter to inherit, then that piece of paper is not going to satisfy the court. If, however, your daughter is the only person you have in your life, then you don't need a will. It can be, your estate can be dealt with through intestacy. That is, that it would go directly to your daughter because she's your only living relative.
I have a question. You mean when you say your only living relative, you mean like there are no brothers, sisters, uncles, cousins, that type of thing, right?
Well, it's an order of what we call consanguinity. I don't know how you're going to interpret that word. It's an order of closeness of blood. So closeness of blood is, for, even though you're not blood related, is your spouse. Then if there's no spouse, your adult, your children, whether they're adults or not, and the court makes certain provisions for minor children. It goes into a trust held for them, a bank account held for them until they're 18. But it would be equally to all your children. So if you have 2 children and one is very responsible and the other is, let's say, homeless or a drug addict or a debtor or is in the middle of a divorce, and you don't want the money to go to the ex-wife, or is in bankruptcy and you don't want the money to go to his creditors, then you need a will to protect that, because without a will, all of your children will share equally.
And what about the grandchildren?
The grandchildren only receive money if their parent is dead.
Okay.
So you have 2 children and one child predeceases you but leaves 2 children. The predeceased child's children will inherit that child's share. Might be easier if I use names. You have 2 children, John and Susan, and John predeceases you but leaves 2 children, Alice and Jacob. John's 1/2 share will go to be split between Alex and Jacob. Does that help?
Yes.
Okay. There's something else that I neglected to mention, and that is that if a spouse leaves the other spouse out of the will for whatever reason, that's the surviving spouse has the right to what's called elect against the estate, which means that the spouse can say, you know what, I don't care what the will says, he can't leave me out. He can't leave everything to his girlfriend and leave me out. And I'm using that example because that's exactly what happened and caused the laws to be changed virtually in every state. Mm-hmm. And so the electing spouse, the surviving spouse who was left out of the will or didn't get enough in the will, gets up to 1/3 of the assets of the estate, plus a car, plus if there's a car. You also get that, and the household items, the furniture.
Wow.
So that even if you want to disown your good-for-nothing husband, excuse me, all those husbands out there, you actually can't. Okay.
Great. Next question, Robert.
There's a request for a bit of a repeat on information on the pre-planning the funeral.
Okay, I'll go over it again. Be happy to. It is possible for you to purchase your funeral arrangements now, pay it off. Most funeral parlors allow you to pay over time because it can be very expensive to arrange for a funeral. And it's either burial or cremation. You can prepay either of those. And then when the time comes, and as we say, it should be in 100 years, when the time comes, all your family has to do is call up the funeral home and say, my mother had a contract with you, and she's passed away. Can you please deal with it? And if you anticipate needing government benefits in the future, you should buy a pre-need, the contract is called a pre-needs funeral agreement. You should get a pre-needs Medicaid approved funeral agreement. That way, the money that you put into the funeral agreement is not recouped, taken back by Medicaid to say that you're not eligible for Medicaid because you had this money available to you. You're only entitled to have a certain amount of money in your name before you are disqualified for Medicaid. You can only have currently in your name $15,750 before you're in assets before you are disqualified for Medicaid. So if you've gotten a funeral agreement, you want to make sure that it's an irrevocable Medicaid approved contract so that Medicaid can't say, well, you can just liquidate the funeral arrangements and spend the money elsewhere. You spent $10,000 on a funeral, let's get that back and pay it over to a home care or a nursing home. I hope that was clear.
Very well. Next question, Robert.
Sure. Is it possible to insert language from a living will document into a healthcare proxy?
Absolutely. A healthcare proxy can be modified, changed any way you want. The only requirements for a healthcare proxy is that you name a person as your agent. You can insert as much language as you want into a healthcare proxy. You can include that you want your organs donated or you don't want your organs donated. You can include anything you want. Next question.
There's requests from some of the attendees to have the information in the presentation, whether it's to have the PowerPoint itself or a copy of the presentation. I'll refer that to the speakers and to Elsia.
Okay.
Sure. I mean, we could definitely forward, as a follow-up, we'll forward a copy of the presentation to everyone.
We have another question here that came externally and was provided prior. Actually, should I be the trustee of my own trust, or should my spouse be the trustee of that trust?
Well, it depends on what kind of a trust it is. There are various kinds of trusts. There's irrevocable, there's revocable. Irrevocable means you can't change it. Revocable means you can change it. There's a supplemental needs trust where you definitely cannot be your own trustee. The supplemental needs trust is the one that will allow you to get government benefits or the beneficiary of the trust to get government benefits. You can be your own trustee. It's not a good idea though. Next question, please.
In a will, if I leave everything to my 3 children, but one dies before me, do the other 2 get the full amount, or do the children of the deceased child get the third amount?
It depends on, it's an excellent question. I'm sorry I didn't cover that. It depends on how you write your will. If you write your will so that you say, in the event that any of my children predecease me, their children, if there are any, receive the money, then it goes to their children. If in the will you say, only my surviving children get the money, that's how it's distributed. Usually when I prepare a will in my office, and this is just my practice, I always ask how the person wants it done. And there's a Latin phrase called per, P-E-R, stirpes, And that means that STIRPES is STIRPES, just so you know if you see it in a document. And it's specifically to allow for the money being inherited by a predeceased child to go to the rest of his blood relatives. His children.
His children.
Any other questions?
Yes, there is another question posted. If my beneficiary dies and I'm not married, but my partner does my partner get the inheritance?
I'm sorry, could you repeat the question?
This is the phrasing of it. If my beneficiary dies, if I'm not married, but my partner dies, but my partner does my partner get the inheritance? It's phrased a bit awkwardly.
All right, I'm going to try and answer what I think is
Sure.
the question. If you have a named beneficiary on your, let's say your pension, and that named beneficiary dies, the pension reverts to your estate. Okay, so let's say I've named my husband as my beneficiary, but he predeceases me and I don't make a new name a new beneficiary, then it will go into my general estate. The general estate would be covered by my will. And so if I leave something to someone in the will, that pension would go, that whatever bank account would go into the estate and would be distributed to whomever. But if you have a partner and you're not a registered domestic partner and you're not married, that person is not going to inherit unless you specifically name that person in the will. And if you don't have a will, that person will not inherit. And I've had more than one person come to me and say, yes, but we were common law husband and wife. Common law husband and wife does not exist under the law unless you have gone to one of two states and have declared yourselves husband and wife in that state. The whole reason that common law marriage was originally developed, the theory of common law marriage, was because people could not access, in the, let's say the West, out in the Wild West when they were, settling the West, there weren't a lot of preachers around or mayors. There weren't even a lot of towns around. So if you declared yourself husband and wife, that was good enough. However, these days, you can always find someone who's been, authorized by the website, some website, to be an officiant at a wedding. And so there's no longer such a thing as common law marriage, except in Pennsylvania. And I think the other state is Texas. You have to go and declare yourself husband and wife in that state in order for New York State to recognize that you were common law husband and wife. It's very hard to prove that you've done that. Very hard to prove. And so you're better off registering as a spouse, registering as a domestic partner, or finding someone on the web who will be an officiant for you and have a little ceremony. Or even better, do a will so that you don't have to marry that person and the will covers it. And by the way, once you've done a will, as I said, you can change the will at any point in time. It's not written in stone. None of these documents are written in stone. All of them can be revoked. Some of them are more complicated to revoke, but all of them can be revoked or changed. And I believe I was saying to Ms. Vasquez earlier today that I had a lady who used to come into my office every Tuesday. Every Tuesday she would come in and change her will. And if by Wednesday we hadn't heard from her, we were worried, because that's what she did on a Tuesday, was come in and change her will. Any other questions?
Sure. We have a question in Spanish. and I'll read that, and our interpreter, who is diligently working in the background. Tengo una hija con necesidades especiales. ¿Cómo puedo protegerla si yo muero y quiero que ella se quede con lo que tenga yo?
So in order to protect whatever you have so that your special needs daughter can continue to get government benefits, qualify for whatever government benefits she can qualify for, and still have that sort of cushion that you might want to give to her through your estate, you have to create either currently, while you're alive, create a supplemental needs trust and put your money into the trust now while you're alive. And a supplemental needs trust will protect her and will allow your trustee, whoever you name, as the person who can distribute money to her for certain items, depending on her benefits. For example, if she gets Social Security, if she gets SSI, you can't use that money to pay for her rent because it will reduce her SSI, but you can pay for cable or her telephone because that won't reduce her SSI. If you don't want to fund the trust now because people don't want to give up control of their assets until the last minute, understandably, then you can create the supplemental needs trust in your will. You need to do a will and include a testamentary supplemental needs trust and name someone. Could be a bank, but they charge a lot of money. Could be a friend, an aunt or an uncle of your daughter, to be the trustee so that your daughter can continue to qualify for SSI, SSD, SNAP, Section 8, Medicaid, and whatever other government benefits she might be receiving, and still have the trust pay for certain everyday items or special items.
We had a question earlier that was just specific to the name of the trust, the pre-need Medicaid approved funeral.
Okay, so that's what it's called. When you go to prepay your funeral at a funeral home, you ask them specifically for a Medicaid approved pre-needs agreement.
Do all my assets need to have separate beneficiaries, or do each of my assets need to have designated beneficiaries? Can I leave a will that says that all that I have goes to all of my children?
So you absolutely can leave a will that says everything goes to all my children. That's the usual will. But if you want to avoid having your children have to go to probate through the probate court, you can put on every asset to be payable on death to, you don't say all my children, you actually name the children, Sally, Jesse, Susan, David, whatever their names are. And you can do that for each and every asset. Most people don't want to bother doing that, so they create a will. And they say everything goes to my children equally, in equal shares. Or they say half go to my children, my three children, so and so and so and so and so and so, and the remainder goes to my disabled child in a supplemental needs trust, for example.
If you did not get the pension from your spouse, the spouse's job can't keep it, right?
It depends on the pension plan. There are some pension plans that when you retire, when the person retires, they can opt for a higher benefit, but then when you die, there's nothing left to the spouse. Or you can get a lower plan, lower monthly payout, but that pension will continue until your spouse dies. There are other pension plans also, but those are the two most common.
And we're getting towards the end of our questions here. We have one, is the power of attorney the one that you use it before the person dies or after the person dies, or both?
Okay. So the power of attorney can only be used while the person is alive. The moment the person passes away, that power of attorney dies with him.
And once I write a living will, a medical will, do I give a copy to my doctor, or what can I do with it?
Okay. So you give a copy to all of your doctors, and you also give a copy to the agent that you name in the will, so that he or she knows that he or she is the agent, and also discuss with the agent what you want and what you don't want in a will for your medical decisions, and then also keep the original somewhere safe in your apartment.
Oh, I think I missed this question from a little bit earlier. Is it better to go to a lawyer for a power of attorney or a will? If you write a will, is it considered legal? This is similar to the previous question that we asked.
Okay, so you can handwrite a will. It's called a holographic will. It is possible to do that, but again, the will has to be executed, has to be signed in a certain way. One of the questions asked at the time that the will is probated was whether the execution was supervised by an attorney. And if it wasn't, they have to ask the witnesses. A will has to be witnessed by a minimum of 2 people, and the witnesses have to be asked, was the person over the age of 18 when they signed the will? Was the person under the influence of any drugs or alcohol that would impair their understanding of what they were doing at the time they signed the will? They have to have been asked at the time that the will was signed by the person who was signing the will, please witness my signing this document, which is my will. It contains what I want to do with my estate and is my last will and testament. And then the witnesses have to ask each other, please witness my witnessing the will. There are a few other questions. Those are the primary questions. Generally, if you don't, most legal Zoom or self-done wills don't have those specifics of execution. And if you don't engage in those specific questions, the will is not valid.
I think we're down to our, sorry, go ahead.
Sorry, the short answer is yes, you can write your own will, but if it's not witnessed in the proper way and signed in the proper way, it's not going to be a valid will.
If I could just interject 1 second. So if I hear this correctly, Emily, there's 3 key things that we need right now, right? The name of this webinar is legal documents you need now, during COVID-19 and after. So would you recommend that, to have something safe, right? To just be safe instead of trying to reinvent the wheel and provide wills handwriting that's going to really pretty much cause an issue after we pass because of all the, back and forth and everything. And I'm a strong believer of always doing it right the first time. Would you say that, there are 3 key elements that someone should have in terms of documents today and after? And that would be 1, the healthcare proxy, 2, a power of attorney, and the last will and testament. Because it sounds to me like the living will is kind of covered with the health proxy, right? Healthcare proxy.
No, the living will is good if you have no one to name. You're old, you're 95 years old, and oh, you've outlived everybody and you don't have anybody to name as your agent, but you don't want to be resuscitated, or you do want to be resuscitated. So
Okay.
you need to give it to your doctor so the doctor can follow your wishes. Okay.
And from all of the documents, the one that I would say, in my opinion, the one that you just do not try to give it a go on your own in terms of finding templates and things like that, where you really need to sit down with an attorney like yourself, would be the last will and testament. Or would you recommend also the healthcare proxy and all the other ones as well?
The healthcare proxy, I think you can do yourself. And if you follow, the correct method of executing a will, you can even do the will yourself. The one you absolutely cannot do yourself is a power of attorney. It's a 10 to 15 page document.
Okay.
It's got a lot of very complicated stuff that can be easily explained and is supposed to be written clearly, but people find it very overwhelming. And also it needs to be, if you want to be able to do Medicaid planning or asset protection, you need to be able to modify it in certain ways, and only a lawyer can do that.
No lawyer can do that. This is terrific. Because I know that you gave us some templates to look at, and we wanted just as draft forms, we wanted to provide it to some of them, but I think the living will and the power of attorney, these are two things that is worth getting to sit down with an attorney via Zoom or whatever during this pandemic, somehow, but have that conversation so that you cover all your bases. There's another saying that I always say in Spanish, and the Latino folks on the call are going to recognize me saying, we say, lo barato sale caro, what's cheap ends up being very expensive at the end. So it's better to do it now. Yeah.
Also, a simple will is very inexpensive. A healthcare proxy and a power of attorney is relative. A power of attorney is a little more money because it's a little more complicated, but they're not expensive. If a lawyer is charging you a lot of money, that lawyer is not very ethical.
Yeah. And as I mentioned to you earlier today before our call, I also think that when you're with the children, the adult children, when their parents are in the hospital, they're very vulnerable because they're dealing with emotions, they're dealing with so many different things. So I think, between the prepaying the funeral and having the healthcare proxy and having the documents we just talked about, the 4 documents right now, I think it's really worth it just for just a regular peace of mind. And you could always go back and change it later on. So it's not something that's set in stone, except of course, the revocable trust, which is, it's key for everyone, because we want to make sure that our hard money in our houses and our properties that we have, everything that we work hard, this is the immigrant dream, basically, from the ground up, building things, that is protected, and that the government, now whether it's here or over there or wherever, whatever country it is, that it goes to the hands of the rightful owners as opposed to the government seizing these properties simply because we don't have a will, we don't have a document or anything like that. So are there any more questions?
I think we just had one that was alluded to in some of what was discussed up until now. How much it costs to do a will. So
okay, I can't speak for other attorneys. Attorneys share a lot of information between themselves, but they never share what they charge for anything. It's just not done.
Yeah, it's not.
But I will tell you that generally, a will should not. A simple will without a trust should not cost more than a few $100s. A power of attorney should not cost more than a few $100s. A healthcare proxy should certainly not cost more than $100, maybe $150, depending. So they're and a living will is the same. It's a minimal amount. And very often, if you do all of the documents at the same time, lawyers will give you a courtesy discount. If you're creating a trust in a will or a trust outside a will, depending on how complicated the trust is, that could run into a few $1,000s. But it depends on how complicated the trust. It may be even less than that.
Are there any more questions, Robert?
I think we've exhausted the questions.
Oh, this is terrific. This is great.
It just popped up. Which one?
Oh, I see it. Yeah, it says it's charging over
Oh, it's in the
$20,000
chat.
a
Okay.
lot with getting Medicaid and trust, etc.
Well, if that person, if that attorney is charging you for also assisting in completing the Medicaid application, it may not be a lot. A Medicaid application is many, many pages long. It requires, depending on whether you're looking at home care or nursing home care, it may require the attorney who's preparing the Medicaid application has to go through 5 years worth of bank records. And if there's unexplained transfers, they have to investigate what the transfers are. So I know more than one attorney who charges a flat fee of $10,000 or more to, and I only know that because I was told by clients, to do the Medicaid application. And then along with the application, you may be doing other documents. So that wouldn't, while it would sort of shock me, it's not out of the realm of possibility. However, you can do the Medicaid application yourself. You don't need a lawyer to do a Medicaid application. It's long and it's complicated, but you can do it yourself. And especially if your loved one is going into a nursing home, the nursing home has, every nursing home that I know about, and I know about most of them, has someone there who will help you with the Medicaid application because they want to get paid. And if you don't have the money, they need to get that Medicaid application in within 3 months of when you run out of money. There are also services that will do the Medicaid application for less money. But really, you can do it yourself. In my office, I encourage people to do it themselves. And when they can't do it themselves, or if they have a question, then they call with a question. But they don't have to pay me, you know, to sit and go through 5 years worth of bank records. If they have another, I'm happy to do it.
Another, I'm sorry, I didn't mean to.
No, please go ahead.
That our communities need this type of information. We tend not to write wills because we think assets are just homes and cars. Please share other types of assets that may be listed in a will.
Okay, so in a will, you can list anything. You can, I often encourage people who have a lot of money and a lot of, or have very, very precious and expensive jewelry. I say, you know, don't mention the jewelry because then you got to get it appraised, and you can do a letter that says, you know, dear family, I want my grandmother's wedding ring to go to my grandchild. I want my my father's watch to go to my eldest son, that kind of thing. Or you can include it in your will, or you can do both. You have books, you have items that may not have any monetary value but are precious to you. I really want all of my pictures to go to my cousin because he's the family historian. Or I want my books to go to the library. I want my favorite statue to go to my favorite niece, whatever it is. And you can put anything and everything in a will. Because otherwise, those personal items are going to end up being thrown out. They shouldn't be, but that's what happens. I hope that answered the question.
Another question that just popped in Spanish. ¿Puede recomendar una compañía que pueda hacer un testamento o dónde comprar una póliza para funeral?
Okay, you can purchase a funeral policy at any funeral home. There are certain life insurance policies that are used to pay the funeral. I don't know any particular policy or any particular company that's good for that, but that is, I know that does exist. With respect to doing a will, you're better off, honestly, you're better off going to an attorney. Certainly doesn't have to be me, but you're better off going to an attorney to do your will than to go to LegalZoom or one of those websites where they say, oh, we'll do your will for $100, because it's going to cost much more than that to try and prove it's a legal will. Primarily because most people don't do the execution the way it's supposed to be done. The execution is when you sign the will.
And then just to add also, Emily, is that we need to make sure that when you go to an attorney, it's like going to a doctor, right? So if you have, if you have a heartache, you don't go to the OBGYN, right?
Right. Most attorneys know how to do a will, but they don't know how to do a supplemental needs trust that will qualify someone for a Medicaid, a disabled child to continue to get government benefits. So you're better off going to an attorney who does trust and estates. You can call the New York State Bar Association and ask for a list of attorneys who do that. You can obviously call my office, but there are
we would like for you to be the one that they will reach out to, because well, we know you. And I think, you're taking this time to explain all of this. I mean, you've been very, very generous with your time, Emily. I think it's important that, again, we do it right the first time when it comes to these documents, but having someone accessible, an attorney accessible, like yourself, that knows what they're talking about, because you also deal with guardianship, right? So you go above and beyond all of this. And like me, you basically changed looking at your bio, what you were doing before, and then you changed to be able to become an advocate for the most vulnerable. I mean, that counts for something.
Well, I appreciate that, and that's a lovely plug. But what I'm trying to
no, I'm not done. I'm not done yet. I want to finish this, okay? Because I mean, when I see you, I mean, I remember my past life when I worked in the financial sector, and I literally changed careers to do this, to build Palante from the ground up. And we're a small nonprofit, but we're growing. But we, the idea is that if you find an attorney, make sure that attorney make sure that they care about you. This is not of a money situation. It's more about making sure that they're taking care of you, that they're legit, that they come highly recommended. I mean, we met you through Jesse Gribbin from Himmelston McConnell. And again, these are other attorneys. So I'm not trying to put a plug into you. I'm just trying to educate our audience that just because there's an attorney doesn't mean that they're going to look at your best interest. And we've seen this in our community, in the communities of people of color. We've seen, I call them ambulance chasers, because they're out there, just trying to take advantage of our people. And, even with personal injury, they're like, well, how much did you get? Oh, I don't know. How much did the attorney get? I don't know. So, we have our own groups, our strategic partners, and attorneys, private attorneys that are actually passionate about helping people. So my point to the audience is make sure whoever you select is an attorney that actually does this for a living, not that just they know how to do it. Anybody can know how to do it, right? The question is, do they do it for a living, and that they actually care about your best needs, because that means that the attorney is going to think forward past what you're thinking to make sure that you're protected and that your family's protected. Go ahead. I'm sorry. Yeah.
Another question just popped up.
Yeah. In Spanish.
She said that you have helped her a lot right now, and she needed help. So
well, thank you
so
for that. Okay, well, so thank you for saying that. That makes me feel good.
Robert, are we done with questions, or are there more?
I just saw another one that popped up in Spanish.
Oh, can we have one more in Spanish? And then we'll let Emily go, because I know that
sure.
With the time, we want her to come back. We don't want to drain her.
Si estoy casada con bienes separados y me pasa algo, ¿qué tengo que hacer para dejar los bienes a mis hijos? O más información para manejarlo. Gracias.
Okay. Well, you can name your children on your bank accounts as the person who would inherit, payable on death or transfer on death to your children, and you can name as many children as you want. And that way it actually falls outside your estate, and your spouse, that is one way of making sure your spouse doesn't get the assets. if you don't want your spouse to get the assets, or you write a will. But again, if you write a will, it's subject to what's called the right of election. Your spouse does have the opportunity to challenge it and get up to a third of your estate. Anything that's not previous, has previous beneficiaries' names. So I encourage people who don't want to do a will and who want to make sure that it goes to certain, their estate goes to certain people, to go to the bank and to name a payable on death or transfer on death beneficiary in each of the accounts. That way you can avoid having to see me.
Bienes is it's real estate, isn't it? Daniel? That's what I'm thinking. Bienes raíces, right?
And consanguinity is surprisingly easier than one would think to translate into Spanish.
Okay, that's
very
good.
Close to the Latin root.
Okay, that's good. All right, so I'm letting Ms. Vasquez know, and anyone from Palantes to know, that I am available to make to answer any questions on the phone within reason. I mean, you know, within reason. So you can get my phone number from Palantes, and I'm happy to answer any questions. They can't be very specific, just general questions. And if I wasn't clear, I will try and be clearer on the phone the next time. I don't speak Spanish, so if you are a Spanish-speaking person, I apologize for being language impaired. And I would ask that you have someone who can translate available when you make the phone call.
Well, tell you what, if anyone there's non-English speaker that would like to speak with you, you met our team members, Robert and Daniel. They're part of our team. They can also help. So instead of giving them your phone number, if they reach out to Palante, we could organize it to see, you know, for them to be able to talk to you, and we could arrange it. And again, you know, we want to make sure that we also are very cognizant of your time.
Okay.
Thank
So,
you. You know, yeah.
Great.
Terrific. Emily, thank you so much. I'm not going to take any more of your time because I know we're going to have you back. We're going to talk about Medicaid, which is something that we definitely want to be delve very deep in. And one thing I should have probably mentioned is I also want to talk about guardianship.
I do a lot of guardianships. I'm happy to talk. There are various kinds of guardianships. There's for adults, they're for for children. An infant in the law is anyone under 18. So I was actually talking to someone and I referred to him as an infant, and he said, I'm 16 and a half. I'm not an infant. I'm sorry.
But yeah, so we would love to be able to bring you back on board so that we could do a series of these to we could educate these folks on, you know, getting it right the first time. And, you know, that obviously coincides with everything we're going through here. And, you know, I wanted to thank everyone. We have 54 attendees are still on the line with us, and they joined us from the beginning. And, you know, I want to thank them. I hope that this was resourceful for them and they learned something. We will be following up with them with the PowerPoint presentation. And I know that Daniel is working on translating the entire presentation into Spanish so that we can send it to our non-English speaker folks. Because again, you know, our knowledge is power in this case, and we need to have these documents. We need to get the stuff done sooner rather than later.
Thank you all very much for your patience with me.
Thank you so much. Thank you, Emily.
Thank you.
We'll talk soon.
Okay, bye-bye.